This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why Oregon allows emotional distress damages for poor claims handling, and why the violation of the bad faith statute allows suit for negligent failure to resolve an insurance claim, and the refusal to pay claims is sufficient to claim emotional distress damages. Christine Moody, individually and in her capacity as the personal representative of the estate of Stephen Troy Moody, deceased, versus Oregon Community Credit Union, an Oregon entity, association, union, or corporation, and Federal Insurance Company, the Supreme Court of Oregon on December 29, 2023, came up with a resolution that made it more difficult for an insurance company to deny a claim. Plaintiff, whose husband was accidentally shot and killed during a camping trip, brought this action against the defendant, a first-party life insurer, claiming, among other things, that the defendant had negligently failed to investigate and pay her claim for policy benefits, causing her to have fewer financial resources to navigate the loss of a breadwinning spouse and consequently to suffer economic harm and emotional distress. Plaintiff's husband was accidentally shot and killed by a friend during a camping trip. Plaintiff filed a claim for life insurance policy benefits, and the defendant initially denied plaintiff's claim on the ground that decedent's death fell within a policy exclusion for deaths caused by or resulting from the decedent being fully under the influence of any narcotic or other controlled substance, apparently based on the fact that the decedent had marijuana in his system at the time of his death. Plaintiff sued, alleging claims of breach of contract, breach of an implied contract, or covenant of good faith and fair dealing, and negligence. Plaintiff sought both economic damages, the benefits payable under the policy, and emotional distress damages. Defendant filed motions to dismiss plaintiff's claims for negligence and breach of implied covenant of good faith and fair dealing, and to strike the allegations seeking damages for emotional distress, arguing that plaintiff's only remedy under Oregon law was contractual. Plaintiff appealed the limited judgment, but while the appeal was pending, she filed an amended complaint that alleged only breach of contract and sought only the amount of benefits payable under the insurance policy, $3,000. Thereafter, defendant paid the $3,000 to plaintiff. The parties stipulated to the entry of a judgment in favor of plaintiff and against defendant, and the trial court entered a conforming general judgment. So we're going to the Supreme Court over the failure to pay a $3,000 claim. Plaintiff takes the position, according to the Supreme Court, that her claim for common law negligence against the defendant for its failure to act reasonably in performing the obligations of a life insurer, and that she's entitled to recover the emotional distress damages that she alleges. Plaintiff's negligence per se claim is a shorthand for a negligence claim in which the standard of care is expressed by a statute or a rule. When a negligence claim exists and a statute or rule defines the standard of care expected of a reasonably prudent person under the circumstances, a violation of that statute or rule establishes a presumption of negligence. The Supreme Court concluded that it is settled that a negligence complaint to survive a motion to dismiss must allege facts from which a fact finder could, 1, determine that the defendant's conduct caused a foreseeable risk of harm, 2, that the risk is to an interest of a kind that the law protects against the negligent invasion, 3, that the defendant's conduct was unreasonable in light of the risk, 4, that the conduct was a cause of plaintiff's harm, and 5, that plaintiff was within the class of persons and plaintiff's injury was within the general type of potential incidents and injuries that made defendant's conduct negligent. Perhaps the simplest legally protected interest is in being free from physical harm at the hands of another. Physical harm includes both bodily injury and property damage. Generally, however, people do not have a legally protected interest in being free from emotional distress. To date, the Supreme Court has permitted common law claims for emotional distress damages only in the following three circumstances. 1, when the defendant also physically injures the plaintiff. 2, when the defendant intentionally causes the emotional distress. Or 3, when the defendant negligently causes foreseeable serious emotional distress and also infringes some other legally protected interest. In contrast to physical harm, emotional harm occurs frequently. Any number of people may suffer emotional distress as the foreseeable result of a single negligent act. Whether the plaintiff had alleged a legally protected interest sufficient to subject the defendant to liability for purely emotional damages caused the court to consider whether the plaintiff alleged a legally protected interest sufficient to subject the defendant to liability for emotional distress damages. To decide whether that alleged interest is a legally protected interest sufficient to subject the defendant to liability for emotional distress damages, the statute, Oregon Statute 746.230, prohibits refusing to pay claims without conducting a reasonable investigation based on all available information and not attempting in good faith to promptly and equitably settle claims in which liability has become reasonably clear. The statute includes conduct that is independent of the obligation to pay benefits due under an insurance policy. For example, the statute prohibits insurers from failing to acknowledge and act promptly upon communications relating to claims, failing to affirm coverage of claims within a reasonable time, and compelling claimants to initiate litigation to recover amounts due. Those prohibitions suggest that the harm that the legislature sought to prevent was not limited to the financial harm that occurs when insurance benefits are not paid. The Oregon Supreme Court will not permit recovery of purely emotional injury unless it determines that the claimed harm is of sufficient importance as a matter of public policy. In this case, the Supreme Court concluded that the question whether plaintiff has alleged a viable common law negligence claim against defendant for emotional distress damages is in the affirmative. It then cautioned, however, that the conclusion does not make every contracting party liable for negligent conduct that causes purely psychological damage, nor does it make every statutory violation the basis for a common law negligence claim for emotional distress damages. Far from it. Few contracting parties promise to provide necessary financial resources on the death of a spouse, knowing that their obligation to act reasonably in doing so is required by statute, and few statutes impose obligation on contracting parties designed to protect the parties from the type of emotional distress and emotional harm that the plaintiff in this case allegedly suffered. The decision in this case is a narrow one that applies and accords with the limiting principles that have been guided by past decisions and does not unfairly expose the defendant to liabilities that it could not have expected and guarded against. Plaintiff, therefore, according to the Supreme Court of Oregon, alleged a viable common law negligence claim against the defendant for emotional distress damages. Therefore, the trial court erred in granting defendant's motions to dismiss plaintiff's negligence claim and in striking her claim for emotional distress damages. In my opinion, the state of Oregon, like many states, has enacted statutes punishing insurers for bad faith claims. The insurer, after a change in the allegations from bad faith to just breach of contract, paid the plaintiff the $3,000 life insurance limit only to find itself sued for negligence claims handling. The suit was dismissed by the trial court and reversed by the Court of Appeals of the Oregon Supreme Court. Since the statute requires fair claims handling, the plaintiff's allegations allowed it to sue the insurer for emotional distress damages when it initially refused to pay because of a clear exclusion. This is a limited decision. It stretches the obligations of an insurer beyond fairness, and even with a clear and unambiguous exclusion, it can be sued for emotional distress. However, this is not something that says that the suit will fall in favor of the plaintiff. She can lose, but at least she gets the opportunity by this very lengthy and strange decision to go to trial for emotional distress damages. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you will have access to the more than 4,700 blog postings. You can also subscribe for free to the videos on YouTube and or on rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. If you found this video to be useful, please tell your friends and colleagues so that they too can subscribe to the blog and the videos. And if you're interested in further detail about insurance, insurance law, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.